So we got this story here from David Showers. David Showers, writing about a Fort Smith attorney who has been at the center of the Arkansas Freedom of Information Act battles in West Arkansas, said that clear statutory language could prevent what happened in Garland County earlier this month when a committee of elected officials, court officers, and law enforcement officials met without notice. Joey McCutchen is that attorney. He joins us now via phone. Joey, how are you this morning?
Morning. Doing good, Paul. How you doing?
I'm doing great. So first of all, tell us about, if people don't know about this Garland County controversy, tell us what happened in Garland County.
Well, I haven't seen all the documents, but it appears that this committee, this Criminal Justice Advisory Committee, met, which was composed of judges, prosecutors, maybe the prosecuting attorney, the JP, met and discussed the closing of the Garland County Jail, and the jail was temporarily closed after the committee met on July 10th. So, the question becomes, is that a government-appointed committee, which would have required notice under the Freedom of Information Act? It's certainly a group of citizens meeting, but those citizens happen to be elected officials, a prosecutor, a judge, a court member. So, whether there's a violation of FOIA or not, it sure looks like that the spirit of FOIA was violated. Those are to me, those are discussions that should be held in the light of day with the media's eyes on them and any citizens that want to be there.
Well, yeah, there's also a new state law, I believe, that's going into effect that requires all public meetings to be captured or recorded in some way as well.
That's right. That's exactly right. One of the really, thank goodness, we finally see a law that is supportive of FOIA and brings more light to government. A law that requires either audio or videotaping of public meetings. Long overdue.
So, here is the Gazette piece where you're asking the question, under what authority are these people meeting? And so, I think that's, and Joey, this stuff like this is happening kind of all across the state. And while this was an in-person meeting, I like that you are such a champion of the FOI law that you think these email chains need to be FOIA-able, or that they're conducting public meetings via email, making decisions, and then they go and they have their meeting in public, and it's all theater. It's all got a predetermined outcome. They know who's going to say what, but they've already decided in email. I think that's happening all over the state, all over the country, really.
No, I think there's no question that it is. I've seen it time after time again. We've currently got a case up against the school board in near Heber Springs, where making those types of decisions through text messages. We've seen it happen in Mansfield, Ozark, Fort Smith. So it's happening all over the state. The Supreme Court recently blurred the lines with their ruling in the Wade case. But the bottom line is, in my opinion, if two folks off of a board are meeting to discuss business that is foreseeable to come before the public body, then that needs to be a meeting that everyone gets notice of. And because otherwise, as you said, we see the final result. All the discussion has already occurred, just like we see in the legislature. Bottom line, they go to the back rooms, discuss the legislation, and then all we see is a final vote with all the discussion done in the back rooms. And, that's dangerous to our republic.
Yeah, it's kind of a daunting mountain when you think of it. How would we ever actually stop just to kind of, pontificate here, how would we actually stop that from happening? Where, I mean, because, you have what the public sees is not what really going on. I mean, at some point, and, disagree with me if you want, Joey, but I mean, at some point, they got to have the ability to talk with each other, obviously, outside of, let's say the General Assembly, or outside of this committee. I mean, can we really expect them not to talk about, this bill or that bill or this idea or that idea outside of the public's view? I mean, should they be wearing body cams the way police officers wear body cams?
Well, yes, we can absolutely expect them not to discuss public business. They leave if they want to discuss the weather or the hogs or something else, that's fine. But if two or more of a school board or a city councilor are discussing public business and making conclusions, then yes, we should be able to expect them not to do that until they're in an open meeting. In an open meeting, they can discuss it as much as they want to. It's this idea of efficiency versus transparency. And transparency, open government should win out every time. Otherwise, all decisions are going to be made in smoke-filled rooms, in closed to the public, and we can't allow that to occur.
Yeah. Yeah, as a matter of fact, hang on a second. There's that C.S. Lewis quote from Screwtape Letters about the greatest evils are not done in those sordid dens that Dickens loved to paint. There it is. I mean, the greatest evil is not done in those sordid dens of evil that Dickens loved to paint, but it is conceived and ordered. It is conceived and ordered, moved, seconded, carried, and minuted in clear, carpeted, warmed, well-lighted offices by quiet men with white collars and cut fingernails and smooth-shaven cheeks who do not need to raise their voices. That's a pretty interesting quote, isn't it?
Yeah, it's very, very interesting. As Justice Hart said in her dissent in this recent opinion, she said that today's majority opinion denies the electorate in Fort Smith insight into the performance of its elected officials and allows those public officials to make their decisions in secret. Secrecy is the poison to democracy.
Wow.
And that's what she based her dissent. And it's absolutely true. Secrecy is the poison to democracy.
It's interesting.
Conduct rewarded, conduct repeated. And if we allow two school board members or two city council members or two quorum court members to discuss the public business that is likely to become before that public body secretly, whether it's on email, text message, or in a conversation in the back room of McDonald's, that's poison to democracy.
Yes.
We want to see those discussions in public.
Yeah, so I mean, it really is a question of ethics. It's a question of honor. I don't think we really talked about this enough. I mean, the devil's advocate position would say, well, Joey, do you not want that? We're friends. Me and school board member, we're friends, and you just don't want us to talk about our day?
You talking about two school board members?
Yeah, two school board members. We're friends, and we want to be friends. And, of course, we're going to talk about this stuff.
Like I said, they can be friends. They can have discussions about things friends talk about, but not public business that's going to come before the public body.
Mm-hmm.
I think what's going to happen, what's going to happen, Paul, is either the legislature is going to have to define what a meeting is, or I'm strongly considering bringing a ballot initiative, filing it shortly before the Arkansas Attorney General, getting it approved, and let the citizens vote on what a meeting is. And the definition that I like is when two public officials are discussing our public business that's likely to come before that public body, that's a meeting. And the the public should get notice through at least the media, and also the people like myself in Fort Smith. And I would encourage all your listeners to contact their school boards and city government, JP, the Justice of the Peace, and tell those bodies that you want notice of all meetings that are occurring.
So, like, let me ask you that, because I'm not opposed to this, but I am just thinking of the process as right now. So how would that work? Like, if you've got a legislator who has an idea, right now they have to go to the Bureau of Legislative Research. They have to say, hey, this is what I want to do. Can you, and there's probably an email chain that's created. There might be multiple legislators, that are now kind of looped in via the email. Hey, this is what we're thinking of doing. So you think all of that should be public?
I think that's a slightly different question. Right now we know that the FOIA meetings provision does not apply to legislators. So that's a slightly different question, but an interesting question, and one that, frankly, I see what happens in the legislature. When Governor Rockefeller created and the legislature approved, the Democratic legislature, Republican governor approved FOIA, they didn't include the legislative body, which to me was one of the things that weakened this law, because he would have never got it passed. So it applies to city council and, city council, local government, government-appointed committees, and certainly that's the way our government should be run, that two of those people shouldn't be able to make their decision, or two or three or four, and then have a sham meeting, which is what's happening throughout this state.
Yeah.
The Supreme Court did make it abundantly clear that these secret meetings can occur by email. All of them pretty much agreed on that point. At least 6 out of 7 agreed on that point. One kind of said that the legislature has not said that, but Paul, we need it defined what a meeting is, and I'd like to see it come through the people and enshrined in our Constitution.
Yeah.
We see all these ballot initiatives and all this stuff they're trying to put in our Constitution. But to me, it would be an important provision to put in our Constitution that public officials, in essence, must do their business publicly.
Yeah.
Where you and I and all the citizens can watch if they want to, and the media gets notice of it so they can report on it.
I can't argue with that, and my devil's advocate arguments are typical. That's what you're going to hear. It's like people want to protect government. They want to protect the process of government. And, we never have, you know what I mean? People, they're going to argue, like with the ethics provisions, like, well, we need to make sure we don't go too far. And attorneys are, you're going to inhibit attorneys from being able to be legislators. We need to make sure we don't go too far with transparency. And it's like, for once, can we? Like, for once, could we just go too far when it comes to disclosure, or go too far and just see what happens? Just see what comes of it. You know what I mean? I mean, we have all these concerns for the status quo, really, is what we're talking about. Like, yeah, this is a problem that needs to be reformed, but we don't want to reform it too much. And I'm just ready to reform it too much. Like, let's make a mistake. We got plenty of mistakes the way things are. Why not make a mistake in trying to correct it with too much transparency? I think that would yield way better results for the people than, say, what we've got now with all this corruption.
Yeah, I mean, we need the light of day on government. That's the bottom line. And this recent Supreme Court decision in the Wade case that I was involved in, it basically said that they have 7 board members on an email chain. 3 of them engage in discussion of public business, getting rid of the Civil Service Commission, make decisions. So if they and the Supreme Court said that was okay. what if 7 of them show up at McDonald's, 3 of them discuss shutting down the Civil Service Commission, make a decision? Is that not a public meeting?
Mm-hmm.
I mean, that makes no sense. There is no way that the Supreme Court or anybody else is going to say if 7 Fort Smith City Council members show up at the McDonald's one morning, they agree to show up at the McDonald's, 3 of them discuss shutting down the Civil Service Commission, and then they have a public meeting later. Do you think somebody's not going to scratch their head and say that that's a public meeting, that the media should have received notice?
That's a good point.
I think yes, everyone would agree with that.
Fort Smith attorney Joey McCutchen. Joey, thank you for your efforts. We really appreciate it.
We're going to keep after them, Paul.
All right.
Thank you.
Yes, sir.
Look for a ballot initiative or legislative action.
I'm excited about that.
What constitutes a meeting?
All righty. Sounds good.
All right.
All right. Thanks, Joey.
Thank you, Paul.
Folks.